We're here today to announce the results of an investigation into a case involving a Lethbridge police officer and the death of an injured deer. On January 8th, 2019, ACERT was directed to investigate the circumstances surrounding an incident that occurred January 5th, 2019, involving an LPS officer who used a marked police vehicle to repeatedly drive and reverse over an injured deer, ultimately killing it. The investigation is now complete. When the incident arose, there was consideration as to whether the matter should fall under the jurisdiction of Alberta Fish and Wildlife Enforcement Branch and whether the Alberta Society for the Prevention of Cruelty to Animals, Alberta SPCA, should be involved. As the nature of the investigation involved the reasonable handling of wildlife calls, something generally falling within the parameters and expertise of the Fish and Wildlife Enforcement Branch, a senior experienced Fish and Wildlife Enforcement Branch peace officer was included as part of the investigative team. This officer's involvement was invaluable, and ACERT is grateful for the assistance provided by the Fish and Wildlife Enforcement Branch. ACERT also engaged the Alberta Society for the Prevention of Cruelty to Animals, which is an organization dedicated to the welfare of animals that encourages the humane treatment of animals through the enforcement of animal protection legislation and through education programs in a community liaison role in this case. The Alberta SPCA was given full access to the ACERT investigation, encouraged to ask questions, and make recommendations regarding additional investigative steps or observed gaps. The Alberta SPCA was satisfied that there had been a full, fair, and objective investigation by ACERT. As with the Fish and Wildlife Enforcement Branch, ACERT would like to acknowledge the involvement of the Alberta SPCA and are grateful for the added level of independent oversight and participation that they provided. As with every case, the investigation and the determinations made were unbiased and objective. All decisions needed to be principled, based on a dispassionate, fair consideration of the evidence, and not based on emotion, sympathy, public pressures, or prejudice. ACERT's investigation was comprehensive and thorough, conducted using best investigative practices and in accordance with the principles of major case management. During the course of ACERT's investigation, evidence was gathered including interviews with police and civilian witnesses, radio communications, computer-aided dispatch records, training materials, and relevant department policies. All were reviewed and seized. The cell phone video that began the investigation was secured and reviewed. The involved officer, although not required to do so, provided a full statement and access to his notes and general occurrence report. Lastly, a firearms expert was asked to examine the investigation in its entirety with a view to obtaining an independent, objective opinion on the risks and benefits of using a firearm in the circumstances of this case. In this release, an act to either accelerate or cause the death of an injured animal to alleviate its continued suffering will be referred to as euthanasia, or actions taken to euthanize. These terms are universally understood and as such communicate this meaning. They are not intended to diminish the seriousness of action taken, nor are they intended to convey reasonableness to any particular method or positive act. ACERT's investigation involved consideration of the Criminal Code, the Wildlife Act, and the Animal Protection Act. As with some of the possible offenses had a 6-month limitation period, the investigation had to be prioritized to ensure no loss of jurisdiction. On January 5th, 2019, at approximately 10:12 p.m., the Lethbridge Police Service received a call of an injured deer on Scenic Drive and 16th Avenue South. The caller advised that the deer was in the northbound lane, was quite injured, and might need to be put down. Those are the words of the caller. At 10:16 p.m., another caller reported the presence of the injured deer and noted that, in the caller's words, it looked broke. The deer was described as dying on the road. It had been an extremely busy night for the Lethbridge Police Service. When the first call came in, there was no one available to take the call, and it went on the board. The first officer was available to be dispatched and arrived on scene at approximately 10:24 p.m. The officer was working alone that night, was in full uniform, and was operating a marked Lethbridge Police Service tactically equipped Dodge Ram 4x4 truck with a secure metal lockbox safely storing tactical team weapons, ammunition, and equipment. The officer had his standard use of force equipment, which included a baton, pepper spray, and tactical knife. In terms of firearms, He had his service pistol. He also had access to a Heckler & Koch MP5, a Remington 870 12-gauge breaching shotgun, and an R1 less lethal launcher. The officer first attempted to determine if the driver of the vehicle that had been involved in a collision with the deer was still on scene or needed assistance. After determining this, his attention turned to the deer. The deer was described as a female juvenile mule deer weighing approximately 60 to 70 pounds with evident significant injury to the hindquarters and rear legs. These appeared to be no longer functioning. While the deer was able to get up onto its front legs, it appeared weak and lacking in the strength to drag itself even a short distance. The officer believed the deer was critically injured, and he made the determination consistent with policy that the animal should be euthanized. The officer considered all of the available use of force options, including his firearms and ammunition options. With respect to any of the firearm options, the officer decided the risk of a possible ricochet was too great given nearby homes, apartments, and vehicles driving in the area. He considered attempting to drag the deer into another location where he could safely use a firearm, but felt this carried its own challenges when he quickly wanted to euthanize the deer as quickly and humanely as possible. This left him with the options of his baton or a similar blunt force weapon such as a tire iron, his tactical knife, and the use of the police vehicle. With respect to the police vehicle, he believed that if he drove the heavy vehicle over a vulnerable, critical part of the deer's anatomy, causing a crushing injury, death would be virtually instantaneous. Unlike some of the other available use of force equipment, such as the tactical knife, there was nothing in LPS policy stating that the vehicle could not be used. The officer was aware of the provisions of the Wildlife Act that prohibited the killing of wildlife with a vehicle. He noted that this provision was part of a regulatory regime meant to govern hunting. This situation had nothing to do with hunting and everything to do with the lawful execution of his duties as a police officer. Having given it very careful thought, the officer decided to proceed with the use of the police vehicle. When the officer drove over the deer, he felt the vehicle move up and down as it proceeded over the deer, so he reversed back over, believing that the deer would now be dead. He was shocked when he saw the deer was still alive and moving around. It was clear that he had missed the deer's head, but felt that the vehicle would have caused crushing injuries to the deer, so that he felt death would still be imminent. It was not. Feeling compelled to finish the job, and with the firearm still not a viable option, he continued to use the vehicle until the deer died. Once the deer was dead, the officer moved it from the roadway onto the cement median. As per protocol, he contacted dispatch to ensure that arrangements were made for city workers to come and remove the deer's carcass. There was no attempt during this incident to contact Fish and Wildlife Enforcement Branch. That having been said, the officer would have been aware of the general availability of Fish and Wildlife Enforcement Branch officers, as well as the existence of a memorandum of understanding between the Lethbridge Police Service and Fish and Wildlife Enforcement Branch. At the time, one of the two Fish and Wildlife Enforcement Branch peace officers assigned to Lethbridge was on annual leave, and the other officer had already worked his shift for the day. The closest available officer would have been the on-call Fish and Wildlife peace officer from Cardston, approximately 80 kilometers from Lethbridge. If one assumed even immediate availability, it would have taken in the neighborhood of 57 minutes or longer for that officer to reach the scene. The video, which is now infamous, was in fact a cell phone video provided by a bystander who had initially seen the collision between the civilian vehicle and the deer and who had returned to the scene. The video is approximately 14 minutes and 47 seconds long. The woman who took the video advised that it was not a complete record of the events. The video began after the first occasion where the officer drove over the deer. In the circumstances, the video can be described as of good quality, being mindful of the fact that it is an amateur cell phone video taken at night. The video shows the police vehicle being driven repeatedly over the deer. The first instance occurs at approximately the 22-second mark on the video, where the police vehicle drives over the deer, front wheels only, and then reverses back over the deer. At approximately the 9-minute mark in the video, the police vehicle drives forward over the deer with both the front and rear wheels, and then reverses back over the deer. Almost immediately, the police vehicle is again driven forward until it appears to stop on top of the deer, where it remains for a little less than 1 minute before it reverses back off of the deer. Shortly after the 11-minute mark on the video, the officer can be seen to exit the police vehicle and move the now dead deer off the roadway before driving away from the scene. While in some instances it is very easy to see that the wheels make contact and run over the deer, as the truck visibly rises and comes down as it progresses over the deer, on several of the attempts there is no discernible movement on the truck as it proceeds in one direction or the other over the deer. In this case, it does not need to be conclusively determined, however, as it is readily apparent that the vehicle did make contact and run over the injured deer repeatedly. That these actions caused the deer additional pain and injury and ultimately its death is a given. While the events reflected in the video can be clinically recounted, the emotional impact of the video cannot be understated. It was and remains profoundly distressing and heartbreaking to watch. It is unforgettable and impossible to unsee. At the time of this incident, there was no established protocol or practice requiring, authorizing, or facilitating an opportunity for a Lethbridge police officer to access veterinary services to euthanize wildlife. Any person can usually access emergency veterinary medical care for animals in any reasonably sized community in this province, and Lethbridge is no exception. In theory, a police officer could contact a veterinarian for advice and/or to request assistance to euthanize an injured animal. While available in theory, the practical reality of trying to find and speak to a veterinarian from the side of the road at 10:24 on any given night presents challenges. Trying to sort out issues such as the availability to a call-out scene, potential liability should a veterinarian be injured during the call, and who should bear the costs associated with a call, all present challenges that are best sorted out ahead of a particular event and not on the side of the road. It is not as easy as it sounds to arrange for that type of call. What is critical for the purpose of this case, however, is that there was nothing in place on January 5th, 2019. Looking at the evidence as a whole, there are certain facts that should be considered as established and the foundation for any examination of the conduct of an officer and whether it does in law constitute an offense. Those facts are as follows. As a result of the collision with a civilian vehicle, the young deer had been left seriously injured, having obvious trauma to its hindquarters and its rear legs. Both rear legs were no longer functioning. As a result of its injuries and incapacitation, the deer was in pain, suffering, and in distress. The injuries were such that the deer was going to need to be euthanized. This outcome would have been the same regardless of whether it involved a Lethbridge Police Service officer or a Fish and Wildlife Enforcement Branch officer. As sweet and vulnerable looking as the deer may appear, it is wildlife, and a critical component of the fact is the fact that it is wild. It was capable of causing serious injury, particularly with its front hooves. This danger is magnified when an animal is injured or stressed. One can expect that it felt threatened and would defend itself. As such, it is reasonable and necessary to maintain a certain safe distance from an injured animal. It was not open to the officer to do nothing. Even if the officer's decision was not to euthanize the injured deer, he still had a responsibility to manage the situation. The animal's presence on the road presented a hazard. It could not simply be left on the roadway. By its very nature, the use of any police officer's use of force tool to intervene and cause or accelerate the death of an injured animal will cause additional pain, suffering, or injury to the animal, unless death is absolutely instantaneous. Additional context should be considered as the various options are canvassed. None of the options are fail-proof. Dealing with a non-sedated injured animal and attempting to deliver a lethal shot, blow, or wound is fraught with the potential for error. The slightest movement on the part of the animal changes the course and trajectory of any blow. What works in theory can go off course in reality. In this case, as in most cases, the police officer did not have animal tranquilizers available. While this is a tool that is available to Fish and Wildlife Enforcement Branch officers, it is not standard law enforcement equipment. Following the release of the polarizing video, people who included experienced police officers were quick to judge the two fundamental aspects of the officer's actions. The first being the decision not to use a firearm, and the second being the use of a police vehicle as a suitable alternative to a firearm. It is necessary to examine both of these decisions to determine whether those decisions and the resulting conduct was criminal. The use of the firearm is obviously, by a considerable margin, the preferred and most advantageous and reliable tool. In general, would have been the first choice and the most humane way to euthanize an animal. One must always be mindful, however, that firearms are exceptionally dangerous, and it is for this reason that it is generally an offense to discharge a firearm within city limits. While this offense does not apply to law enforcement engaged in the execution of their duties, it is a recognition that there are inherent dangers associated with the discharge of firearms in populated areas. In this case, the officer was able to articulate extensive reasons why the use of any firearms or ammunition that were in his possession would have been ill-advised and in some cases contrary to Lethbridge Police Service policy. Following the release of the video, there was rampant speculation as to why the officer did not use a firearm. One prevailing theory was that the use of a firearm would have required him to file reports and paperwork and the paperwork involved would have been too onerous. A second, completely speculative theory was that the officer simply wanted to cause the animal additional suffering. Regardless of the theory, the substance seemed to be that the officer made the decision he did motivated by factors other than the best interests of the public and the most merciful approach to euthanizing the injured deer. The evidence obtained during ASERT's investigation would appear to dispel these theories. The decision not to use a firearm did not release the subject officer from his duties to make notes and file a report. Both of those tasks were done on January 5, 2019, in compliance with policy and before the matter ever became public. Evidence that the officer had previously responded to injured deer calls and during those calls had used a firearm to euthanize an animal demonstrated that this was not about a general inability or unwillingness to use a firearm. The officer was also able to articulate well the many concerns he had regarding the safety of using any of the firearms and ammunition in his possession to kill the deer. It was clear that the officer's subjective belief that exercising reasonable care required the elimination of the use of a firearm. Whether the firearm was an appropriate tool was very much a judgment call. In these circumstances, the officer's perception and belief need not be the only possible view, it need only be reasonable. During ASERT's investigation, a firearms expert opinion was obtained reviewing the investigation in its entirety, and that opinion concluded that the use of a firearm in the environment that the officer encountered on January 5, 2019 gave rise to the risk of a ricochet through a missed shot or more likely through the over-penetration of the deer. The smaller size of the juvenile deer significantly increased the opportunity for any caliber firearm to over-penetrate and exit the animal. Further, the various ammunition types had the potential, following a ricochet, to cause harm to persons in the area, be they outside, in a vehicle, or within a structure. The risk of ricochet combined with the proximity of persons in and around the incident created an unreasonable risk to public safety. The only way to have reasonably mitigated the identifiable risk of ricochet would have been moving the injured deer to a more suitable location that would allow for the safe discharge of a firearm. This would have been difficult to do safely and would have involved dragging the injured animal to a safer and more secluded location. This would have necessarily caused additional pain and suffering to the deer. Based on the above, the decision of the subject officer not to use a firearm was both subjectively and objectively reasonable. Having made the determination that the deer needed to be euthanized, of the remaining available tools capable of causing or accelerating the death of the injured deer, none of them were particularly palatable, nor were they necessarily guaranteed to cause a swift death. The remaining options fell essentially into two categories: those capable of causing blunt force trauma and those capable of causing penetrating wounds. With respect to the baton, tactical knife, and tire iron, they would have required the officer to get into much closer proximity to the deer, placing the officer's personal safety at risk. Notwithstanding its small stature, the front legs and razor-sharp hooves of a deer are capable of causing significant injury. Furthermore, even though it was in a weakened state, the deer was still fighting. If the video of the police vehicle running over the deer was a distressing video, a video of the death caused by blunt force trauma or stabbing would have been an unimaginable horror, as the results would have been much more visual and visceral. It is always easy to be critical of an officer's use of force with the benefit of hindsight. In this case, with the benefit of hindsight, it was immediately apparent that the use of the police vehicle did not work well nor as intended. The law is clear, however, that an officer's conduct should not be assessed based on the circumstances as they were known, should be based on the assessment of the circumstances that they were known at the time, and not through the lens of hindsight. In assessing the reasonableness of the subject officer's decision to use a police vehicle, a number of things are clear. The officer carefully considered all of his options. The evidence would have suggested that at all times he was acting in good faith, trying to make the best decision for the situation, which included a desire to dispatch the deer and end its suffering, not to extend it. Unexpected or unintended consequences do not necessarily make the original decision unreasonable. Of the identifiable remaining options available to the officer to euthanize the deer, without the benefit of hindsight, the police vehicle may well have been the best in a pool of bad choices. Even with the benefit of hindsight, as difficult as it is to watch, it is hard to believe that the use of the police vehicle was worse than having to watch the officer attempt to beat the deer to death with a baton or cut the throat of the deer. Taking emotion out of the equation, the officer was able to put the deer out of its misery within approximately 15 minutes. The one factor that weighted against the reasonableness of the decision to use the police vehicle is the Wildlife Act statutory prohibition against using a vehicle to kill wildlife. This factor was not, however, determinative. Any assessment of reasonableness should also recognize that the animal could have been permitted to die naturally. It was not, however, an option for the officer to simply, having decided not to euthanize the animal, leave the scene. In addition to appearing callous, to simply leave the deer, suffering and in distress. The presence of the deer on the roadway was a hazard, a distraction to drivers. It would have been an option, however, to block off the portion of the roadway and allow nature to take its course. If the deer was going to die, it would do so. There are and were a number of reasons why this would have been an unreasonable choice. Firstly, it seems particularly callous to allow an injured young animal to continue to suffer on the side of the road for an indeterminate period of time. It could have been minutes and it could have been hours. The deer would have undoubtedly continued to struggle as it had been doing before the officer arrived. Secondly, the seemingly natural solution would have been resource intensive. Applying a practical lens, the deer's presence on the roadway presented a hazard that would have required scene management for an indeterminate period of time, including arrangements to be set up, barricades or block portions of the roadway with police vehicles, and the redirection or management of traffic. This must also be considered in the context of an extremely busy night where calls for service to Lethbridge Police were stacking up. As indicated, the use of the police vehicle to kill wildlife would constitute an offense under the Wildlife Act. The full investigation was forwarded to the Alberta Crown Prosecution Service for their opinion. While nothing was done to limit their review, it was made clear that in the opinion of ACERT, there were no reasonable grounds to believe that the officer had committed an offense under the criminal code. Additionally, the Crown was advised that in ACERT's opinion, the Animal Protection Act was not engaged by these circumstances. As there was evidence that the officer had used his motor vehicle to kill wildlife, however, there was evidence capable of providing reasonable grounds to believe that an offense had been committed. It should also be noted, however, that the purpose behind the creation of this offense was not aimed at the conduct in this case. A review of cases where this offense has been charged would suggest that it has generally been in the context of a person or persons chasing, harassing, or running down otherwise healthy wildlife in an obvious attempt to cause distress or harm for their own personal amusement. The policy behind this provision has also been to penalize this type of behavior, but also to prevent those engaged in recreational hunting in the province from using a vehicle for that pursuit. ACERT having received the Crown's opinion, it was their conclusion that there was no reasonable likelihood of conviction for an offence under Section 33.1 of the Wildlife Act, nor was it in the public interest to prosecute such an offence. While not asked to do so, the Crown noted that it agreed with the assessment of ACERT that there were no reasonable grounds to believe an offence was committed under either the Criminal Code or the Animal Protection Act. When the officer responded to the call, it was apparent that the animal was suffering and that both policy and common sense required the officer to euthanize the deer and end its continued suffering. The officer clearly considered the potential benefits of using one of the firearms in his possession and the potential risks associated with each. Having recognized the objectively real risk of ricochet, given the placement of the deer, the lack of a safe backdrop, the immediate proximity of homes, apartments, high traffic of the public, and an inability to safely ameliorate the risk, the subject officer made the correct decision not to use a firearm. Notwithstanding its obvious benefits, the officer's decision to prioritize the very real risk of potential injury to a person over the deer will always be considered the correct one. While others, including other police officers, might have felt they could have safely used a firearm in the circumstances, one need only look at a recent Ontario event to find a similar event where the opposite decision was made with almost catastrophic consequences. On November 9th, 2015, York Regional Police, responding to a call for service involving an injured deer, made the decision to euthanize the deer and end its suffering. After discussion, the decision was made to use a firearm. People in the vicinity were moved to what was believed to be a safe distance away, and the roadway was temporarily blocked to prevent traffic through the area. Even with all of these safeguards, when the officer shot the deer, the bullet went through the deer, ricocheted off the cement sidewalk, and struck a 78-year-old man in the head, the bullet lodging between the skin of his skull above one of his ears. It was nothing short of miraculous that the man was not killed during this incident. The subject officer exercised the same careful consideration of his available remaining options. He considered possible legal impediments, factored in LPS policy, and made a principled decision based on the careful consideration of his training and experience. The test is not whether all officers in a similar position would have reached the same conclusion, but whether the conclusion reached was reasonable. It was not the officer's intent to cause additional unnecessary suffering, and short of an instantaneous death, however, it was inescapable that additional pain or suffering might occur until death transpired, regardless of the method chosen. With the benefit of hindsight, it is obvious that the decision to kill the deer using the police vehicle was problematic. It did not work as the officer had intended. The deer's ability to move and the inability of the officer to clearly see where the vehicle tires were in relation to the critical organs of the deer frustrated the attempts to cause fatal injury. That having been said, no method is perfect and complications or problems can occur. This does not render the officer's conduct criminal or unreasonable. ACER having reviewed the investigation and the Crown opinion, the decision has been made that the officer will not be charged with any offences. Any questions? And all of this is available in the press release that will be provided.
So the name and the rank of the officer aren't being released?
ACER never releases the name of an involved officer unless that officer is charged.
And what made this case leapfrog over the case of the
So
contract?
as we stated earlier, a number of provincial offences were considered when assessing this case. Provincial offences have different limitation periods than criminal code offences. Some of them have 6-month limitation periods, some of them have 18-month limitation periods. So in order to not lose possible jurisdiction to prosecute an offence, if it was the Crown's decision to prosecute, we had to meet that 6-month limitation period to provide all possible options.
Can you talk about, are any recommendations being made to police?
So ACER doesn't traditionally make,
Sorry.
ACER doesn't typically make recommendations to police. We don't investigate from a policy standpoint or make policy recommendations. We investigate from a criminal standpoint and determine whether or not there are reasonable grounds to believe a crime was committed. In this case, we determined that there was no criminal offense.
Did I understand during your presentation, though, that since then they do have some policies that are in place that weren't?
You'd have to ask Lethbridge Police about that.
And I also have an unrelated question, but about Calgary, an incident in Calgary today. We were wondering if you could comment on it.
That occurred as we were getting on a plane, so while I have a general familiarity with that, I'm not briefed on that incident to the degree that I'd be prepared to talk about it at this point. I expect within the next day or so we'll be able to release something publicly on that.
There's a lot of people that were engaged with this story and are going to be very unhappy with the conclusions you guys came to. I imagine the accusation will be that you were just protecting a fellow officer instead of coming to the truth of the matter and just not wind in this person's career. I guess, what do you want to say? Those people are going to be extremely unhappy with this decision.
I think first of all, the passionate reaction is a reflection that Canadians and Albertans in general value the lives of animals and care about their suffering. As we said, though, it is important that that passion not supersede reason, and that a full and fair investigation be allowed to take place. It's not fair to the officer to judge his actions based on a public reaction. They have to be based on the actual evidence and the law as it stands.
Now, what is the procedure in place recommended by Alberta Wildlife in this case so it doesn't happen again, so that we know what the procedure is?
So I think you'd have to ask Alberta Wildlife about what their recommendations are for that.
Would it be using a firearm?
Use of a firearm is a preferred option, but that obviously depends on the ability to do that safely. No further questions?
Actually, just, was there any was there any information that came forward that would have allowed the officer to call for assistance at all during the time when he was making his decision?
So as I outlined, the officer did not call Fish and Wildlife Branch for assistance. We did, however, look into the availability of officers in town. Neither of the two Fish and Wildlife enforcement officers who were stationed in Lethbridge were on shift at that particular time, and the closest officer would have been, by our estimate, 57 minutes away.
And perhaps another police officer could have come to assist and or to provide input on what may or may not have been done.
And I wouldn't want to speculate what the outcome of that would be. Another police officer, however, would be similarly equipped. The advantage of calling Fish and Wildlife is that they may have tranquilizing medications that would provide a different option. Calling another Lethbridge Police Service officer wouldn't necessarily bring any additional options to the table.
Was there discussions with the officer involved and his supervisor back at the police station?
Not to my knowledge.